We are about to start the session from a few seconds from now. So a humble request to all the participants to be on the camera on the panelist link so that you get the opportunity to ask questions to all the stalwarts. A warm good evening, good afternoon, and good morning to this August gathering and to all the participants joining from different parts of the world. I, Professor Chainika Basu, welcome you on behalf of Dr. Vishwanath Karad, MIT World Peace University School of Law to the first International Symposium on Law and Peace on the theme, The Role of Law to Promote the Culture of Peace. Before we embark on this thought-provoking journey of knowledge, as per the traditions of MIT World Peace University, we will pray to the Almighty to seek His blessings with the World Peace Prayer, a prayer that is above any caste, creed, or religion. So I request all of you to close your eyes and with folded hands to remember the Almighty. I request my technical team to play the World Peace Prayer.
नमो जीयाद्या वेद प्रतिपाद्या जय जय स्वसंवेद्या आत्मरूपा देवातुति गणेषु सकलार्थमतिप्रकाशु म्हणे निवृत्तिदासु अवधारि बोधि गुरुर्ब्रह्मा गुरुर्विष्णु गुरुर्देवो महेश्वरः गुरुसाक्षात् परब्रह्मा तस्मै श्री गुरवे नमः। पूर्णमिदं पूर्णात् पूर्णमुदच्यते पूर्णस्य पूर्णमादाय पूर्णमेवावशिष्यते। ॐ शान्ति शान्ति शान्तिः।
Thank you so much. Dear delegates, after witnessing an overwhelming participation from participants all over the world in the first 2 days of the first International Symposium on Law and Peace, organized by MIT World Peace University in association with Pune District Bar Association. Ladies and gentlemen, I welcome you to plenary session 5, which is on the theme, The Truth Behind the Testimony. We are about to witness a very interesting deliberation from all the dignitaries who have joined us from different parts of the world. Ladies and gentlemen, it is indeed my honor and privilege to introduce the moderator of the session, Advocate Priyajit Pandey, practicing law, High Court of Judicature at Patna. Advocate Priyajit Pandey is a practicing lawyer in the High Court of Judicature at Patna. His area of expertise pertains to diverse fields: criminal law, civil law, taxation, trade and commerce, banking, etc. He has successfully represented some of the renowned entities such as the Tata Projects, the Jindal Infrastructure Private Limited, Kirloskar Brothers, Keller Groups in the state of Bihar, which finds its place in published judgments. With that, Priyaji is an empaneled advocate for Blue Sapphire Healthcare Private Limited. We welcome you, sir. Ladies and gentlemen.
Thank you so much. Thank you so much. I'm highly obliged.
Thank you, sir. Ladies and gentlemen, I'm indeed happy to introduce the first speaker of the session, Professor Dr. G.I. Linenthal. Dr. Gary Linenthal holds a Symbiosis Silver Medal in National Security Law. He has a diploma in journalism, a Sydney University law degree, a graduate diploma in legal practice from the College of Law in Sydney, Australia, a certificate in criminal intelligence analysis from UK Police, a graduate certificate in psychoanalytic studies, a graduate diploma in psychoanalytic studies, a master's degree in psychoanalytic studies from Deccan University in Melbourne, Australia, and a doctoral degree by research in commercial law from Curtin University. He also holds a United Nations certificate in international dispute resolution. His psychoanalytic interests lie in the fields of criminal forensic psychotherapy and of organizational behavior, including organizational change leadership through action research. He is a leading thinker on the application of psychoanalytic concepts and techniques, as well as the principles of intelligence analysis to forensic organizational analysis. A hearty welcome to you, sir.
Thank you, ma'am. It's a great pleasure to be here with you all today. First, shall I address Dean Parasar? Dear colleagues, you want to say more?
Yes, sir. If you allow me, can I introduce all the speakers and then...
Oh, I'm sorry.
No problem, sir. Ladies and gentlemen, please allow me to welcome the next speaker of the section, D.O. Okaini, Senior Lecturer, Nigerian Law School, NEU Campus, Nigeria. D.O. Okaini was called to the Nigerian bar in 2002. He has an LLB honors from the prestigious Ahmadu Bello University, Zaria, LLM from the University of Jos, and is currently in the last lap of his PhD research in the NEU State University of Science and Technology. D.O. Okaini was into private practice for over a decade before he joined the academic faculty of Nigerian Law School as a lecturer in 2012. He is currently a senior lecturer in the Department of Criminal Litigation, Nigerian Law School, NEU Campus. Welcome, sir. I'm extremely happy.
Thank you very much.
Thank you, sir.
It's my pleasure to be here.
I'm extremely happy to introduce the next speaker of the session, Professor Omuni Bukola Akinola. Professor, Law and Head of Department of Private and Property Law, Elizabeth University, Ilara Moki, Nigeria. Professor Omuni Bukola Akinola is a professor of law and head of the Department of Private and Property Law at Elizabeth University, Ilara Moki, Ondo State in Southwest Nigeria. He is a secretary of the ENBA Law Journal and the editorial secretary of Elizabeth University Law Journal. His research interests include corporate law practice, legal ethics, legal education and research. He is the editor-in-chief of African Journal of Law, Ethics and Education. Akinola is published in scholarly journals and books. A hearty welcome to you, sir.
Thank you very much, except to add that I got appointment as the Dean and a Professor of Law at Redeemers University in Osun State, Nigeria. So I'm no longer in Elizade. I just moved from Elizade University to Redeemers University in Ede, Nigeria. Thank you very much. It's nice being here.
Congratulations. Too. Congratulations.
Thank you.
Ladies and gentlemen, please allow me to introduce the next speaker of the session, Advocate Makaran Arkar, Senior Advocate, Supreme Court of India, New Delhi, Bharat. Makaran Arkar is a practicing advocate in the Supreme Court of India New Delhi. His specialization includes central excise and taxation, civil, company secretaries, corporate, criminal, and the divorce laws. A hearty welcome to you, sir. Now I shall request Professor Anuradha Parasar, Dean, School of Law, Faculty of Liberal Arts, School of Visual Arts, and School of Performing Arts for addressing the gathering. Over to you, ma'am.
Basu, Sadar Namaskar to one and all, respected dignitaries on the dais, distinguished honorable members of legal fraternity who are attending this meeting online, as well as those who are present here, respected Honorable Chief Justice, Honorable Justice of Supreme Court, High Courts, Honorable Sitting Judges, Honorable Former Judges, distinguished senior advocates, members of Bar Association, advocates, lawyers, fellow colleagues, participants, members from media and press, faculty, staff, and my dear students. A very good afternoon to one and all. And here in India right now, it's afternoon 2 p.m. So please accept my greetings as per the respective time zone. Welcome one and all to this technical session on the truth behind the testimony of the first International Symposium on Law and Peace at Dr. Vishnath Karad, MIT World Peace University, Pune, Bharat. MIT World Peace University is organizing this International Symposium in association with Pune District Bar Association, and we started the symposium on December 14th, and it was a very grand inaugural session, and we'll be concluding this symposium on December 17th with the valedictory session. And in between, there will be 8 technical sessions. And this is also one of the technical sessions, as I said, the truth behind the testimony. And the theme of the symposium is role of law to promote the culture of peace. And at the outset, I wish to express gratitude and thanks to a good number of members, advisors who has helped us in the making of this symposium. First of all, I wish to express gratitude and thanks to Honorable Revered Professor Dr. Vishnath D. Karad sir, who is President, MIT World Peace University. We also express gratitude to MIT WPU International Symposium Law and Peace patrons and organizing chair, Honorable Executive President Shri Rahul V. Karad, and to Dr. Lalit Basinji. We also express gratitude to MIT World Peace University School of Law Advisory Board members, Shri Nanik Rupani, Justice Dilip Karnik, Advocate Makarand Adkar, and sir is also one of the speakers in today's session. Advocate Satish Manishinde, Advocate Anand Desai, they all are the advisors for School of Law at MIT World Peace University. Advocate Aniket Nikam, Advocate Ravi Kini, Advocate Rajendra Shirodkar, Advocate Mohan Pungalia, Advocate Mrunalini Deshmukh, Professor Dr. K.L. Bhatia, Professor Dr. Dilip Uke, Advocate Sudhir Vakure, Advocate Anita Agarwal, Advocate Aditya Pratap, Advocate Komal Joshi, Advocate Kapil Khair, and Advocate Satish Mullik. And I also take this opportunity to welcome and express gratitude to all distinguished speakers of ISLP technical session, all the legal luminaries who are gracing right now the virtual dais of International Symposium on Law and Peace. And we keenly look forward to your address on the truth behind the testimony. Thank you. Vande Mataram. Jai Hind.
Thank you, ma'am. Thank you so much for perfectly setting the tone of the session. Now I shall request Dr. Anjali Sane, Associate Dean, School of Commerce, MIT World Peace University, for the welcome address. Over to you, ma'am.
Thank you, Dr. Basu. On behalf of our Honorable Revered Founder President, Dr. Vishwanath D. Karad sir, Honorable Executive President, Shri Rahul Karad sir, respected Vice Chancellor, Dr. Ravi Kumar Chitnis sir, Dean Dr. Parashar, and the entire team at ILSP, it is my proud privilege to propose the welcome address on the occasion of session 5 of the International Symposium on Law and Peace on the topic, The Truth Behind the Testimony. It is my pleasure to welcome the eminent speakers of today's plenary session, Advocate Priyajit Pandey, Professor Dr. G.I. Lilienthal, D.O. Okani, Professor Omani Akinola, Advocate Makaranda Adkar, members of the legal fraternity present here today, pro-vice chancellors, deans, directors, heads of school, dignitaries on and off the dais, and all the ladies and gentlemen present for the session. According to Plato, good people do not need laws to tell them to act responsibly, while bad people will find a way. This is as per Plato. On behalf of the entire team of MIT World Peace University, I extend a hearty welcome to all the speakers for gracing today's function. I would also like to welcome Dr. Lalit Bhasin for the session and all other eminent luminaries who are present for the session today. Thank you all for sparing time from your busy schedule and accepting our invitation. Dear all, transparency, noticing the way the witness is giving the testimony, and if they are hiding any information, is one of the most important roles in the court of law. The behavior of the witness in the court and how close the evidence is to the logic has to be judged. The role of witness is very crucial in determining the outcome of a case. The party producing the witness in the court tends to give a favorable testimony on behalf of the party that has produced him, and the testimony of such a witness is negated by the adverse party. A tough situation arises when the favorable witness turns hostile. The credibility of the testimony of such a witness and the impeachment of the credibility of his testimony unnecessarily leads to the prolonged trial of a case, which in turn vitiates the direction of the court in its quest for truth. In case if a prime witness in a case turns hostile, the court in that case will have to search for other circumstantial evidence in reaching a conclusion for the case. The fate of a case will be doomed if, on a crucial aspect of the case, the court will have to dispense with the testimony of the witness and depend on circumstantial evidence. However, despite using many methods, telling if the witness is telling the truth remains a big challenge yet to overcome. The aim of the session is to discuss issues like what leads to a witness turning hostile, what is the truth behind the testimony of the witness, so on and so forth. We hope that discussions and deliberations in the International Symposium on Law and Peace will lead us to definite conclusions and would help us in establishing peace in the world. Finally, I would like to quote Benjamin Disraeli when he says, "Justice is truth in action." Once again, I welcome one and all, and on behalf of the entire team, extend a warm invitation to all eminent speakers to visit our campus in Pune for an on-campus, or as they say, an offline interaction with our faculty and students. I'm sure that our faculty and students will definitely benefit with the in-person interaction with all eminent dignitaries present here today. Thank you one and all for gracing today's function, and I look forward to the entire session. Thank you once again. Over to you, Dr. Basu.
Thank you, ma'am. Thank you so much. Ladies and gentlemen, please join with me in welcoming the eminent personality, Dr. Lalit Bhasin, sir, who has joined us in spite of his hectic schedule. Welcome, sir. Ladies and gentlemen, of course, as per the new normal, we have to capture this moment because there are certain moments in life which we just can't we can't just let it go by. So therefore, and this is such a moment which we would like to treasure throughout our life. So therefore, a humble request to all the panel members to put on their video with a beautiful smile on the face so that this moment can be captured for a lifetime. Thank you. Thank you so much. The theme of this session is the truth behind the testimony. As we know, the witnesses are a crucial part of a criminal case, with their testimony being the major proof either in favor or against the accused, providing a fair judgment delivered on the principle of justice. It is alleged that the present judicial system has completely taken the witness for granted. Witnesses are summoned to the court regardless of the fact that they may not have enough money. They cannot leave their family, they come from remote areas, and reaching the court every now and then might not be easy for them. And that's not all. When they appear in the court, some of them are told the case has been adjourned and they are given another date to appear in the court. Now, is it one of the main reasons that the people are not willing to become witness in a case even if they want to? Or what is the reason that they turn hostile? Let's discuss. On that note, I shall formally hand over the session to the moderator, Advocate Priyajit Pandey. Over to you, sir.
Greeting to all the members present. At the first place, I feel very overwhelmed to be the moderator of this session, that too in the august presence of such eminent speakers. So greetings to all of you, all the members who are present in this virtual meet, International Symposium. So the topic, the theme of this meet is the truth behind the testimony. So at the first place, before we start talking about testimony, let's get into the origin of the same, from where testimony came into, how testimony word was coined. At the first place, before we shall start, I'll just give you a gist of the same as to how things are.
Sir, if I'm allowed to interrupt, I think the participants will have a better hold of the topic if they could just witness a session video which have been specifically made for this. I request my technical team to release a session video.
For sure.
Over to my technical team.
The role of a witness is very crucial in determining the outcome of a case. The party producing the witness in the court tends to give a favorable testimony on behalf of the party that has produced him, and the testimony of such a witness is negated by the adverse party. A tough situation arises when the favorable witness turns hostile. The credibility of the testimony of such a witness and the impeachment of the credibility of his testimony unnecessarily leads to the prolonged trial of a case, which in turn vitiates the direction of the court in its quest for truth. In case if a prime witness in a case turns hostile, the court in that case will have to search for other circumstantial evidence in reaching a conclusion for the case. The fate of a case will be doomed if, on a crucial aspect of the case, the court will have to dispense with the testimony of the witness and depend on circumstantial evidence. The session will deal with issues like what leads to a witness turning hostile, what is the truth behind the testimony of the witness, and so on and so forth.
Yes, sir. Over to you.
Yes. That was quite a brief video about explaining about testimony. So as I was saying, testimony, when we understand the literal meaning of testimony, we go back to ages. At the first place, testimony comes from a Latin term that is testimonium. So when we go into the Anglo-European root as to understand what does this mean, it means third, it means three. That means it is something which is the third person. So the testimony can be given by a third person whom we call as witnesses, in quotes. But now the question which arises, is it necessary for a witness to be a third party? Can't there be a person who is an accomplice to the crime? Can't he be a witness? So that is something which is different in different countries. When we talk about India, we have section 133 of the Indian Evidence Act, which involves even the accomplices to the crime to become the witness, depending upon the corroboration of other evidences that is necessary. So yes, so at the first place, when we talk about testimony, the literal meaning means three, which means for the third, and that gives the invitation to witnesses. Now, when we have witnesses, so when this theory came into force, is it something that required a statute, or is it something that required a recognition? But no, it is not something just like law, just like what Austin says, just like what Salman says. that definition of law at the first place as to how law came into force. In the same manner, it is something with testimony. It is something which was already present, which was something as an instinct for human beings, that testimony always prevailed. And thereafter, it is an evidence which one says orally, and that is subject to chief examination, cross-examination. So the examination in chief and cross-examination is done to the person taking an oath, giving a direction in the court, making a statement regarding a crime, regarding the knowledge of a crime, or might be to facilitate the justice system. So that is the place wherein we talk about testimony. So from the literal meaning, when we say it is three, that means third and the witness, then what is the situation in India? In India, we very well understand that testimony can be given by a person who has even committed a crime, who is even an accomplice to the crime, depending upon the collaboration of evidence. Now, moving further, if we talk about specifically the psychology, so when we say testimony, when we say witnesses, it means memory game. This is something all related to memory, how much one understands and what one understands. So psychology is something which is having a great significance with witnesses, with the memory of witnesses. So for an example, let me tell you this, that if you are in a courtroom, want to give a testimony regarding a case wherein one of the close member of your family has been killed, and you are in the court about to give an evidence, the testimony has to be recorded. So there is a way in which the lawyers does the cross-examination. There are times wherein the lawyers might ask you comfortable question quite in a very soft tone, as to your name, as to your work, as to everything. But the moment you will be asked uncomfortable questions, the voice might be raised by the lawyers themselves, just for making you feel uncomfortable in the courtroom. So that is where the psychology also behind testimony is equally important as to how it works. In India, we have relevant sections of the Indian Evidence Act that who may testify, that is section 180, which says anyone can testify who can understand the question, even a person who is disabled, even a person who cannot communicate verbally. They all have the provisions for giving testimony depending upon that they understand the question which is being asked by the court. So testimony in definite sense, it is one of the most essential thing which law works with. It is not without testimony. Testimony is something which prevailed from always. It was there from the beginning and it is present without a statute. It was always present and we have a history for it. It is not something which is new and which requires a statute. If we talk more, then we have the credibility. If someone is giving a testimony, then what is the credibility of that testimony? Whether it is a hostile testimony, whether it is something which, and it all affects the rendering of justice. It all affects the justice system. And that is why testimony is a very important topic to talk about. There are three things which is very important while analyzing the testimony. The three things are whether the truthfulness, authenticity, as well as the genuineness, whether it is genuine, whether it is truthful, or whether it is authentic. Now, these three things are having parameters of psychology. So, at the first place, as the moderator, I just wanted to give a gist of everything what I feel is important in the field of testimony, in the field of law. This is the main reason why witnesses have to play a crucial role. So let's even talk about electronic evidence over here. Electronic evidence is something which is there. It is emerging every day. Electronic evidence is helping for speedy justice. Now, whether can we say it is a testimony? So because for testimony, we need an oral or written form of evidence to be produced in court. But the truthfulness and genuineness of even the electronic evidence has to be done by way of oral evidences. That has to be done by way of testimony. So that is something which is very important. And in India, we have different laws, different prohibitions. So for an example, if a client is coming to an office, If a client is coming to the office of an advocate, and if the client is sharing all the things such as the crime which the client must have committed, so those all things are something which needs confidentiality. The advocate cannot become a witness for the same. The judges cannot be compelled to be a witnesses for the same. So all these things are very crucial to be spoken about, and we have the great speakers with us today, the eminent members who will guide us through the different stages and different perceptions which they have for testimony, as to why testimony is so important in the field of law. And the psychological part of testimony is very important as to how the legal fraternity, as to how the justice system should work in the field of psychology. Why psychology is very much important in the field of law, in the field of, especially when it comes to testimony, why is it that much important? So that is something which is very crucial. So with that, I'll be calling upon the speakers. So at the first place, may I please invite Professor Dr. G.I. Lilienthal for starting with the, for guiding us as to what he perceives regarding testimony. Over to you, sir.
Thank you, sir. Dear colleagues and students, after that exhausting introduction, I feel that my presentation isn't on topic, but we'll do it anyhow and see. I'm going to speak about truth in digital evidence. There are some problems with digital evidence. Let's go through it. Now, this presentation is not something the nature of which you would have heard every day. This is in the nature of meta-legal critical analysis. It's legal theory. It's not so related to practice, but it's a very important critique of practice. So let's look at truth in digital evidence. The research that grounds this presentation was in a 2016 article that I and my co-author, Professor Ahmad, published in the Malayan Law Journal in 2016, entitled Search and Seizure of Digital Evidence, a multi-jurisdiction contextual analysis, where we analyzed English law, American law, and Malay law. But I'm not going to do a contextual analysis today. We'll just stick to the theory. So let's talk about the contextual background. Concern about general warrants, because we have to delimit this research today to criminal law, because arguably it's much more important than the civil law. Consequences are much greater. Concern about general warrants versus specific warrants was a matter that was settled in the 1765 English case of Entick and Carrington. It's a landmark case in England, still underpinning much legislation around the world, relating to police powers of entry, search, and seizure. The problem is, of course, that the police get a warrant to search for a specific thing that they've persuaded the judge they need to do. And then when they get to your house to do the search, they search anything they can, find anything they can, and charge you with other things that up until this moment they had no idea that you may have committed. That's a problem. It's a problem in due process, in the warrant process. So in the Entick case, the defendant broke into the property of the claimant with a warrant to search for seditious papers. This is very important because, as I show in my research on sedition, published in the Commonwealth Law Journal, at that time, sedition was defined in the English courts as anything the judge thought it was. So it was complete, unfettered judicial discretion to find somebody guilty of something. The court held that the person who provided the warrant had no authority to do that because, by the way, he was a member of the executive and not the judiciary. And so Mr. Carrington was liable for trespassing. He was the police officer. If the police don't have a valid search warrant, they can be liable in trespass, criminal trespass. The decision of Lord Chief Justice Holt in Queen versus Tutchin had introduced a bad tendency test into the required elements of sedition. A bad tendency test, which means if you, from examining your personality, tended towards badness, then you may be found guilty of sedition. It assumed that any criticism of the government had a tendency to undermine the government, whether that was true or not, and that any proof of intention to publish that criticism was all that must be proved in court for a finding of sedition. So you can see now the relevance of sedition in Entick and Carrington and how it introduces the idea of unfettered administrative discretion in something important like the criminal law. So the most notable issue in this case was the law surrounding the power of the police to search property. Lord Camden, who was the Chief Justice of the court, said, "By the law of England," he said, "every invasion of private property, be it ever so minute, is a trespass. No man can set foot upon my property without my license, but he is liable to an action, though the damage be nothing." Now you have to know that it's only in recent times that trespass has been a civil action. In the old English law, all trespass was criminal. In fact, in the old English law, there was no tort, there was only crime. Similar situation in Chinese law, where civil laws are dealt with by government departments much of the time, although less and less these days, and most of the law is criminal. So the judgment in this case indicated that acting under a general warrant where the police could look for anything, constituted an act of trespass. Lord Camden further stated, he said, "I cannot help observing in this place that if the Secretary of State, who issued the warrant, was still invested with the power of issuing this warrant, there was no occasion for the application to the judges." See, if the Secretary of State could grant a warrant, then the judges are bypassed. Said Lord Camden, "For though he could not issue the general search warrant, yet upon the least rumor of a libel, he might have done more and seized everything." This is what we call in philosophy a slippery slope argument. And a slippery slope argument is a semi-fallacy. When you see one of those, you should be suspicious. So let's look at the Commissioners of the Inland Revenue against Rossminster Limited. In that case, and others somewhat qualified the principle of the Entick case. So in Rossminster, the warrants were obtained against several persons, including Rossminster Limited, a corporation. The police and revenue inspectors searched the relevant premises together and seized a number of documents. They did not inform Rossminster of the offences of which they were suspected, nor did the search warrant contain particulars of the alleged offences. The House of Lords decided that the warrants issued were within the revenue's powers and the suspects had no right to be told the nature of the offences alleged against them. Well, this is a surprising decision. So what we say here psychologically, that this represents a regression in the law. From Entick back to Rossminster is a regression. It points to a natural reversion towards a de facto general warrant, meaning that police could search widely and assemble and construe or misconstrue evidence of the various elements of a crime, where the evidence was not necessarily connected by the subject's conscious mens rea. The effect of this process might be a reversal of evidentiary onus in certain circumstances, so that the defendant would have to prove the evidence did not constitute a crime. And in the English common law, we are kind of proud of the fact that crimes cannot be reverse onus, but there are ways procedurally of making that happen. So let's look at the three phases of police collecting digital evidence. It's very interesting what happens. You may not know what they do, so let's expose it now and open it up. And keeping in mind what we've just learned, that the law was what was stated in Entick, and it regressed to Westminster, giving the police all kinds of power, some of which I will argue still remains. So police collection of electronic evidence in computer-related cases typically takes place in three phases. Please remember these phases. First, collecting stored evidence from third-party servers. They do that without entering anyone's house. Then prospective surveillance, once they get an idea of what direction to go in. Then finally, the forensic investigation of the suspect's computer, maybe necessitating going to the suspect's place of work or the suspect's house. These three phases represent the unique mechanisms of collecting digital evidence while it is in transit, gathering digital evidence kept by forthcoming third parties, and securing digital evidence kept by hostile parties such as the suspect, because the digital evidence moves between servers and computers and can't really be pinned down to the one location. So what do the police do? So these investigations are rarely simple. The trails of the evidence are usually broken somewhere, sometimes many times along their paths. The police have to piece all this together. Systems administrators rarely keep detailed records, and if they did, they probably would be deleted after a short time. You can't expect somebody to fill the whole computer just with records of what went through it. Large official record systems may, however, be maintained according to certain ISO standards. Not everyone is ISO accredited, so the police can't guarantee that they can find the evidence when they're looking for it. So these standards may address maintenance of data, explaining the primary data's context. So hackers or other information gatherers have traditionally targeted in between the computers with poor quality record keeping, so hindering the police in their investigations. So the hackers can prevent the evidence from constellating for the police by hacking as the evidence moves between the servers. Therefore, the police investigation must deploy prospective surveillance by the use of a logging system to observe future internet packet streams and record them. There can be invasive wiretapping to intercept emails, or there can be a monitoring of the most immediate source address of some attack. And there's the reference for that information. Okay, so an analysis of the suspect's computer could show, for example, the bank password used to arrange an unauthorized account. It could reveal records from that account or from intermediary computers. It may be possible to tell whether or not the attack was launched from the seized computer. But do you see what's being said here? The inference is it may not be possible. Just because there's a bank password and account details doesn't mean the crime was launched from the seized computer. This could be persuasive evidence of guilt by connecting the attack to the suspect's private computer, and it could go some distance in removing reasonable uncertainty. So the police and their systems managers really have a lot of work to do. It's not easy for them. Now, I'm not going to read this to you, but I'll just tell you that when the police seize the computer, they take it to the lab, their systems analysts use a special program to make a mirror copy of what's on the computer's disk. It's called see here, a bitstream copy. And it's said to be an exact duplicate of every bit and byte stored on the suspect's drive. Now, if you were the judge in such a case, how could you possibly satisfy yourself that the police had made an exact copy of the disk drive on the seized computer? You don't know what's happening with these disks, the way they process data in the background, and you don't know what the systems administrators are really doing. This is a problem in digital evidence. What's happening with the digital copy? The police analyze the digital copy. They don't analyze the original computer disk. So already we have something like a hearsay situation, a kind of a machine hearsay. Brenner noted as follows, and listen to this: during normal computer use, many temporary files are created and deleted by the operating system. That's something nobody can control. Additional files are created, deleted, or modified by the specific actions of the user. If the computer system is in continual use, older information will be overwritten with newer information. The more the system is used, the more evidence will be lost. So, if you are a criminal using your computer to commit a criminal offense, and you know these things, then obviously you just get very, very busy on the computer you use for the criminal act and do more work on it in the hope that many of the files will be overwritten by the operating system. An example is the simple act of starting a Microsoft Windows system destroys more than 4 million characters of evidence, and the spoliation will be far greater if the system is used to run any programs. So you see, the process of getting digital evidence is quite fraught. So when the police seize and analyze the suspect's computer, a warrant is required covering both the two elements of entry and seizure. You need to specify in the warrant the issues of entry and the issues of the nature, the specific issues of seizure. We already know that they're going to be seizing a computer, but they don't know what's on the computer disks. So already we have a problem of a general warrant merely due to the nature of the evidence being on a disk. It's customary in the warrant rules to try to make sure that the search and seizure remains as narrow as possible. And of course, the judge or the judicial officer or the court registrar, whoever it is, the magistrate, who issuing the warrant would want to be very careful about that. Naming the specific site to be searched and the particular evidence to be seized. The classic situation, of course, is searching for a bank fraud or money laundering case evidence, and then they find pornographic photos on the computer. And the question is, can they charge the person with holding the pornographic photos when the warrant didn't provide for it? As this says, seizure is limited to the evidence particularized in the warrant. Limited further by the scope of probable cause in the United States. I don't know whether you have probable cause in India. We certainly don't have it in most of the Commonwealth countries. So these rules are supposed to prevent warrant searches devolving into general warrants. But can you see the inevitability of the regression here from entic to Rossminster. It's absolutely inevitable due to the nature of the disk drive and the computer. Seizure of the whole computer is necessary for reasons of practicality. They take the whole computer away to the police station, but might have been hard to justify in reference to the customary rules. For example, if you need the disk drive, why do you have to have the power supply in the computer? So arguably, this is evidence of the theoretical regression we discussed earlier in this presentation. So Kerr suggested, and he's the authority in this paper here, Digital Evidence and the New Criminal Procedure in the Columbia Law Review, he's pretty much the world authority on the legal theory of digital evidence. He suggested that most often the computer is only a storage device for evidence. It is not the evidence itself. The computer is not the evidence. Three kinds of evidence: documentary, oral, and real. The computer is not real evidence, and the court has to be cognizant of that. The evidence is the electronic file, and as we have discussed, it's highly ephemeral. It's stored alongside many harmless files contained within the physical computer. Thus, seizing the whole physical computer only to get a small number of files might be overbroad. Kerr suggests it's analogous to seizing a house and taking it away to mine it for evidence of some stated crime. This is the regression we talked about earlier on. Now, we're moving along nicely in the presentation. Let's have a look and just go back to what we've already discussed, this copying process, making the bitstream copy. When investigators generate a bitstream image of the seized computer, there is an arguable need for legal regulation. The imaging process allows the police to recreate its own apparently perfect copy of everything on the suspect's computer disk, but what's to stop the advocate who's acting for the defendant to allege some kind of recent invention? With this apparently perfect copy, police can mine it for leads limitlessly, just as for a general warrant. There is your regression again. Okay, now we've covered it. Now let's see what the effect of this, and there's only a couple more slides to go. I've almost finished. I know it's been a little complicated, but what's been the real effect on the court of this regressive process in evidence? And our moderator, the advocate, our moderator, explained to us earlier on the name of testimony. Testimony. It's actually biblical. But we won't talk about the nature of it because it's not a family discussion, but it's a biblical source, and it relates to the kind of argument that the court has to identify in the case. And so we have, developed by Cicero and developed by Quintilian, a theory called the theory of stasis. That means in the dispute between the complainant and the defendant, it's moving because there's an argument, there's a dialectic. Where does it stop and what kind of stop is it? This is called stasis theory, and the smarter advocates understand how to analyze a case like this. So the strongest method of self-defense is, if possible, to deny the charge. I didn't do it. If the police come to your house and allege something and you deny it, they probably won't take you away and arrest you unless it's very clear that they know you did it from irrefutable evidence. The second best is when it's possible to reply that the particular act with which you are charged was never committed. So if the police accused you of murdering somebody and you go into the house and you bring the person out and say, here she is, she's alive, then you can argue that the murder never took place. The third and most honorable is to maintain that the act was justifiable. Yes, I killed the person, but it was under the doctrine of necessity or self-defense with proportionate self-defense. If none of these lines of defense is feasible, there remains the last and only hope of safety. If it is possible either to deny the charge or justify the act, we must evade the charge with the aid of some point of law, making it appear that the action has been brought against us illegally. And the judge can see this strategy instantly. The judge sees that the defendant is arguing in this way, and the judge knows this is a weak defense. So you can see that this is a weak form of stasis. So some point of law, in the case of digital evidence, making it appear that the action has been brought illegally. That's what we're talking about. This forces the defendant into the lowest form of stasis. I argue that digital evidence forces the defendant into the lowest form of stasis, thus automatically impugning the quality of truth in the defense, despite an arguable trespass into the defendant's property. Why? Because there's been a regression from Entic to Rossminster, because the police have made a bitstream copy that none of us know is good or not. But the fact that the police are in court making allegations is very powerful. And all we can do in a situation like that is argue that whatever has happened, that no law has been broken. Weak form of stasis. That concludes my presentation. Ladies and gentlemen and dear colleagues, I'll stop the share and return the screen to you.
Thank you, Dr. Lilendra. Please exempt me if the pronunciation is not correct. Thank you for apprising us regarding so many information, that to the electronic evidence. I would just like to share one thing summarizing your argument, that the discussion which we just had, which we just heard, is somewhat even present in India. We also have the clone making process, like the electronic evidence. We don't give the physical computer in the court. It's something that the clone is being made. And in India also, we have section 65B, which is whenever there has to be a certificate in section 65B, and then only the electronic evidence would be considered as maintainable in the court. So then only it will happen. So thank you so much, sir. And with that, I would like to call upon the next speaker, which is Mr. Dio Okani. Yes, sir. Please, over to you, sir.
Good afternoon, ladies and gentlemen. It is my pleasure to be invited as a part of this very important symposium. I want to specifically thank the organizers of this symposium, the MIT World Peace University, for inviting me to be a part of this very important discussion. As a matter of fact, I find the theme of this symposium quite apt. The symposium is talking about law and peace. What this means is that the MIT World Peace University is actually living up to its name in the propagation of peace all over the world. And I also find this quite instructive, that the topic I'm going to discuss this morning is managing a hostile witness, the Nigerian experience. It is important to start by saying that there is a synergy between law and peace. The essence of law actually is to ensure that there is peace in the society. And the creation of courts is also in tandem with this objective. Courts are created to avoid a situation where citizens will resort to self-help in the ventilation of grievances. When you approach the courts, it means that you have submitted yourself to the jurisdiction of the court, And it also means that we have opted for a peaceful settlement of the conflict as against self-help. Now, when you go to court, there are expectations. Parties are expected to state their case before the court and allow the court to decide. This presentation essentially, though the topic covers both civil and criminal procedure in Nigeria, I'm going to be emphasizing the procedure in criminal matters as it relates to the role of a hostile witness. First, it is important to understand why the place of a witness is very important in a trial in Nigeria, be it criminal or civil. The onus of proof is usually on the party that alleges. Otherwise, it is called he who alleges must prove. So when you present a matter before the court, there is an expectation that the burden is on you to convince the court to decide in your favor. In criminal matters in Nigeria, a defendant is presumed to be innocent until the contrary is proved. That's the provision of section 36, subsection 5. Now, the burden of proving the guilt or otherwise of the defendant is on the prosecution, and the standard is beyond reasonable doubt. This places a very important task on the prosecution in a criminal matter to lead credible evidence to convince the court on the reason why the defendant should be convicted. Now, in order to discharge this onerous burden placed on the prosecution, it will either have to rely on confessional statement where there is one, or circumstantial evidence, or evidence of witnesses who witnessed the event in question. So the evidence needed in proof of the allegation could be real, it could be documentary, it could be oral. Instructively, in Nigeria, on the strength of the provisions of section 125 of the Evidence Act, all facts could be proved through oral evidence, except the contents of a document. So in practice, you find out that about 75 to 80% of matters in court are proved through oral testimony of witnesses that are called by the parties. Now, this leads us to the issue of examination of witnesses, because it is actually through examination of witnesses that the issue of hostility arises in a trial, be it civil or criminal. Now, in Nigeria, under Nigeria's Evidence Act, by the provisions of section 214 of the Evidence Act and 215 of the Evidence Act, the examination of a witness by the party who calls him is called his examination in chief. Now, a party shall first be examined in chief, and then if the other party so desires, cross-examine, and then if the party who called him so desires, re-examine. Examination in chief is that process by which the party who has called a witness elicits evidence in proof of the case before the court. It is actually in the course of examination in chief that the issue of hostility of a witness arises. Now, that takes us to the issue of a hostile witness. Who is a hostile witness? According to the case of Esan and the state, a hostile witness is that witness who bears a hostile animus against the party that has called him and does not intend to give his evidence fairly with a view to telling the truth. Now, there are certain basic things we need to understand about a hostile witness under Nigeria's Criminal Justice Administration. The mere fact that the evidence of a witness is unfavorable to the party that has called him does not ipso facto make that evidence a hostile evidence or make that witness a hostile witness. It is the fact that the witness is unwilling to testify, or even where he chooses to testify, he is unwilling to tell the truth, that makes him a hostile witness. So the judge is saddled with the onerous responsibility of distinguishing between answerable to the party that has called the witness and that which clearly makes the witness a hostile witness. Hostility could be caused by either malice, intimidation, corruption like bribery, or just sheer mischief or unwillingness, sheer unwillingness to tell the truth. Now, under Section 230 of Nigeria's Evidence Act, a party who has called a witness is prohibited from impeaching the credit of that witness. In fact, in the case of Babatunde and the state, it was held that a party who has put forward a witness is presumed to have put him forward as a witness of truth. And to that extent, it is forbidden for that same party to impeach the credit of the witness. Now, the only section of the Evidence Act 2011 that appears to speak directly to the issue of a hostile witness is Section 230 of the Evidence Act, which I had mentioned earlier. It states that a party is not allowed to discredit his own witness, except if it appears in the opinion of the court that that party has turned hostile. Now, one thing we need to pick from this section is that the court has a very important role to play in the determination of whether a witness has become hostile or not in Nigeria. What is more, even when in the opinion of the court a witness has turned hostile, it is not the prerogative of the party that has called the witness to brand the witness a hostile witness. He must apply to the court to brand the witness a hostile witness, after which he will be given an opportunity to lead evidence to contradict the evidence of that witness. However, it is instructive to note that the permission given to a party who has called a witness who has turned hostile to cross-examine him does not extend to the opportunity to lead evidence in regards to previous statement made by the witness without seeking the leave of the court. So there are two levels. The party who has called the witness who has turned hostile must first invite the court and apply to the court to brand the witness a hostile witness. Thereafter, if he intends to impeach the credibility of the witness by leading evidence to show that the witness had earlier made statements which are inconsistent with the oral testimony in court, he must seek the express leave of the court to be able to do that. Now, it is important to state that in Nigeria, so much powers are given to the judge in the determination of whether a witness has turned hostile or not. Let us look at this scenario. A party who has called a witness, from the witness's demeanor and body language and even oral evidence in court, believes that this witness is no longer reliable, that he has become hostile, and applies to the court for purposes of recognizing that witness as a hostile witness. What happens if, in the opinion of the court, that witness is not qualified to be branded a hostile witness? That foils a situation of fait accompli on the party, because the prerogative is that of the judge. And unfortunately, there is no guideline on what the court will look at in the determination of whether a witness has turned hostile or not. Some of the things that in practice the judge looks at is the demeanor of the witness, the body language of the witness, the overzealousness of the witness, or the preemptiveness with which the witness anticipates the next question. Now, these are left to the vagaries and the idiosyncrasies of individual judges. But what is agitating my mind is the fate of the party that has called the witness in the unlikely event that the judge is unable to agree with the party that the witness has turned hostile. Now, another thing we need to understand about the place of a hostile witness in Nigeria is what happens when a witness is even recognized by the court as a hostile witness. Now, I said it earlier that one of the things that would happen is that the party will be allowed to cross-examine the witness, in which case he will be allowed to impeach the credit of the witness. If you go to section 231, 232, up to 233 of the Evidence Act, it outlines the procedure for the party who wishes to impeach the credit of the witness by calling up statements that the witness had made earlier in order to prove that the witness has become hostile and unreliable. Now, one of those things is that the party is allowed, with the leave of the court, to confront the witness with earlier statements made. Understandably, in criminal matters, during pre-trial investigation, witnesses are usually invited to the police station or before other law enforcement agencies for purposes of making statements. It is actually on the strength of the favorable nature of the statements made by such witnesses that the party feels confident to invite such witnesses to court to testify. So under Nigeria's Evidence Act, there is usually an opportunity for the party who has called a witness who has turned hostile to exhume such statements made during pre-trial investigation for purposes of confronting the witness and establishing before the court that the witness is not only a witness that is not willing to tell the truth, but that the witness is such that the testimony should not be believed. But what is the overall effect of such procedure on the case of the party that has called the witness? Now, it is unfortunate that unlike the provision in India and made to understand, I think under section 154 of the Evidence Act of India, a party is allowed to cross-examine with the leave of the court a witness that he has called. Now, that does not mean that he has to apply to the court to declare the witness a hostile witness. And when such cross-examination is done, the court is at liberty to choose the part of the evidence of that witness which is favorable to the case of the party that has called him in the determination of the case of the party. That is not the case in Nigeria. Once a witness has been established to be a hostile witness and the court, in its opinion, has agreed that such a witness is a hostile witness, the implication is that the evidence given by such witness is to be disregarded or expunged from the record of the court. Now, that is the only remedy available to the party that has called the witness. The court does not rely on the evidence, even when any part of the evidence appears to be favorable to the case of the party that has called him. Because the moment the party opts to inviting the court to brand the witness a witness, it is deemed to have abandoned the witness and his evidence. I think that's a form of amendment, because where the witness who has chosen to be hostile is the only witness that the party intends to rely on in proof of his case, where does the party go from there? That is another challenge we have. Now, another thing we need to understand about the provisions of the Evidence Act concerning a hostile witness is that where a witness turns hostile and the party that has called him is not proactive enough to identify the hostility in the nick of time and make appropriate applications before the judges, the implication is that such testimony given by the hostile witness is deemed an admission which could be used in the reinforcement of the case of the adversary. So that leaves a lot of work in the hands of the party that has called the witness or his attorney to be proactive enough to identify at the earliest possible time that the witness has gone hostile and apply accordingly. Otherwise, whatever evidence that is given by such witness will be used in the reinforcement of the case of the adversary. Now, another thing we need to understand is that under Nigeria's Evidence Act, since so much powers are given to the judge and little remedies are left in the hands of the party who has called the witness, there must be recommendations on what the party could do to ensure that its case is not completely defeated. I would want to recommend that in the case of maybe expert witness, there should be a code of conduct for expert witnesses, which will make it possible for an expert witness who chooses to give his evidence unfairly or with a desire to propagate falsehood to be punished using such code of conduct. Now, it is also important to note that under the tremendous strides made in Nigeria's criminal justice administration, front loading, which has hitherto been the prerogative of civil matters, has crept into our criminal jurisprudence. So it is now possible for witnesses to make depositions, and such depositions filed before the court. And at the point of hearing, what you need to do is to invite the witness to simply adopt the depositions. That doesn't give the witness the liberty to tell lies, because the depositions are usually on oath. And if in any case the witness decides to abandon a deposition which he made on oath, it borders on perjury for which the witness could be appropriately punished. Now, I also feel there is a challenge because one of the things that a party could do when you are dissatisfied with the decision of a trial court is to leverage on the privileged position of the appellate court to present your case for the scrutinization of the appellate court with a view to addressing whatever injustice you have received from the trial court. Now, because of the peculiar situation that surrounds the issue of a hostile witness, the judge is usually invited to study the demeanor of the witness and make findings as to whether, in his opinion, the witness has become hostile. It is usually difficult for an appellate court to follow the findings of a trial court that are based on facts, because it is the prerogative of the trial court to study the demeanor of witnesses and make findings based on facts, which prerogative is not available often to an appellate court. So on the whole, it is my submission that the situation as it relates to a hostile witness in Nigeria is such that we have made some improvements, especially with the 2011 Evidence Act, but we still have room for improvement because of the importance role the oral testimony of a witness plays in Nigeria's criminal justice administration. Thank you very much for your attention.
Thank you so much, sir. I'm confident that everyone must have understood the Nigerian Evidence Act in detail. It was such a good summary, sir. And perhaps I would say that the Indian Evidence Act is no different. Most of the provisions which sir just guided us right now is present in the Indian Evidence Act as well. Thank you so much, sir. And the hostile witness explanation which you gave was very good, sir. Thank you so much. It was very informative. Now, I would like to call upon the next speaker, Professor Omuni. Yes, sir, are you present? Professor Omuni Bukola.
Yes, sir, he's present. Professor Omuni, can you please unmute yourself?
Yes, he's present.
He's present, sir.
Please unmute yourself, sir. Yes.
Hello, good morning from Nigeria. So happy to join you
Good
at
morning.
the MIT University for Peace. And it's a great initiative. I would like to share my slide, so you have to enable me to be able to share my slide. I have a slide to share. Can you hear me?
Yes, sir.
Kindly, the host should please enable me to share my slide. The setting is still showing that only the host can share the slide.
Yes, sir. Rights are given. You can share.
Okay. Let me attempt to share my slide. Okay, it's still showing only the host can share the slide. Can share the screen. So please kindly enable screen sharing.
It has been permitted, sir.
Okay.
It has been permitted.
Okay. Okay. Still showing the same thing
Yes.
at my hand. Okay, let me quickly go on to what I have to present this morning. Let me quickly go on to what I have to present this morning. Now, the truth behind the testimony. Let me first commend the organizers of this event and admit that this is a great initiative at a time when global peace and security is being threatened, especially in Nigeria, with so much terrorism going on in the northern part of Nigeria. Now, being invited at a time like this to look at truth behind testimony, I must say, is commendable. And it's not only commendable, but a great initiative of this university. Now, I'll be looking at the ethical dimension to this. Ethical dimensions to it. To obtain the truth from witnesses as far as getting or extracting the truth from the witness testimony is concerned. Now, be that as it may, starting from the motto of this symposium, Heralding law to promote peace, you will discover that if there is no truth in what a witness is saying, there won't be justice. And as long as there is no justice in what the witness is saying, as long as there is no justice in what the witness is saying, there will be anarchy. There will be anarchy. And because we don't want anarchy, that's why at a time like this it's very important to look at what is evil truth. I said I am looking at it from the ethical dimension. What is truth? Have we attempted to define or look at what we mean by truth? Now, we said truth is a virtue. Truth is a virtue which we ought to cultivate from the family circle, which we ought to cultivate from the school setting, which we ought to cultivate from our various governmental institutions. We shouldn't find it difficult to get the truth from an incident, a dispute, a matter, but because of our debased value system, we find it difficult to extract the truth today. So we can say truth is what is true. It is also a fact or belief. That is still truth. Truth is a fact or belief. So please go in the line of those definitions. Sometimes the truth is an eyewitness account. I take it again. Sometimes the truth is an eyewitness account. And because it's an eyewitness account, the truth could also be a feeling. The truth could be a feeling. For instance, in an incident of rape or sexual molestation, who will be saying the truth? The rapist or the victim. So it is the duty of us as advocates to extract the truth. And if as advocates we need to extract the truth, then it's a question of skill. What skill do I as an advocate need to get the truth out of this testimony? And that is what I'm going to premise my submissions on in this morning's presentation. Now, what is testimony? Testimony is a formal written or spoken statement, especially one given in a court of law. We said it's a formal written or spoken statement